Hi and welcome to the first of two training videos on understanding statelessness in the Syria refugee context. These form part of a broader online toolkit to help people who are working in the refugee response to understand the ways in which statelessness interacts with their work. You'll be hearing from a number of experts about what statelessness is, why statelessness can affect refugees, and what can be done about it. What is the distinction between a stateless person and a refugee?
Well, a refugee under international law is someone who has a well-founded fear of being persecuted on particular grounds and who is outside his or her country of origin and lacks the protection of that country.
Article 1 of the 1951 Refugee Convention defines a refugee as someone who, owing to a well-founded fear of being persecuted for various grounds, is outside the country of his or her nationality or habitual residence.
Some refugees can, of course, be stateless, but not all refugees are stateless, and likewise not all stateless persons are refugees. The definition under international law of a stateless person is someone who is not a national, so has no nationality at all, is not a national from any state under the operation of its law. Hence, some refugees can indeed be stateless, but not all refugees are.
Article 1 of the 1954 Statelessness Convention defines a stateless person as someone who is not considered as a national by any state under the operation of its law. What matters for this definition is whether somebody holds a nationality. They needn't have crossed an international border, and indeed many stateless persons remain in their own country.
The 1951 Refugee Convention, Article 1A2, which provides the definition of a refugee, does allow formally for a refugee to be without a nationality. So there's two situations here. One whereby the root causes of statelessness itself can result in the person feeling the need to move into a different country and being a refugee as a result of that, or that person has already moved and for reason or another, whilst in their new country, finds it incredibly difficult, if not impossible, to acquire a new nationality if they're born, for instance, whilst in exile, or finds it difficult to just find the documentation to prove their nationality.
The need to understand statelessness when working on refugee issues.
It's not surprising that stateless persons are among one of the quite numerous groups of asylum seekers. It's a perfect proof of to what extent statelessness can actually induce forced migration and actually force people to leave the place they call their home. In a case of an armed conflict, stateless populations can be extremely vulnerable. They have even less means than other parts of the population to find internal protection, for example, in the country. They may find it increasingly difficult to find protection in a neighboring country. So probably they are even more motivated than the others to take the extremely dangerous route towards Europe.
We talk more about citizenship as the sort of as a positive means of asserting citizenship, and I've been thinking about it less from the point of view of statelessness, if you like. But actually, as we've gone through, there have been specific groups that have really come onto our radar who are either stateless or at risk of statelessness. And I'm thinking most particularly about Burundian refugees in Tanzania who were offered the choice of naturalization or repatriation. And 162,000 opted to be naturalized. But there was a very long, complicated process to then get their citizenship certificate. So they renounced their Burundian citizenship, and because they weren't allowed dual citizenship. But many of them still now don't actually have their certificates, although the government of Tanzania is now moving the process forward. So in that kind of interim period, there was a real concern that they were going to become a stateless population. And there are also a lot of concerns around the split of Sudan into two countries, people who were left effectively, if you like, on the wrong side of the border.
Why is it important to identify situations of statelessness among displaced populations?
I suppose because being a refugee and a stateless person does add to the predicament of the person in question. In particular, regarding issues of naturalization, access to basic rights, such as services, healthcare, education, the right to work, etc., for which one usually needs to be a national of a country in order to be able to access those rights. So being a refugee and being stateless overlap to a great extent in that regard, in that both have lost basically the protection of their country of origin. But being stateless and a refugee has this added notion that more needs to be done for these persons, for these people, because should they ever be allowed to return back to their country, there's a problem itself with the issue of return if you can't show that you can be returned to a particular country since you don't have the nationality of that country.
There are a number of reasons why states, for example, European states, have to identify who are the stateless in a mixed migration flow or in a migratory forced migration context. First of all, when it comes to refugees, it's very important to know who are the stateless refugees, even though their legal status in Europe would be quite much the same. They would receive refugee status. But for example, for durable solutions, it will be already necessary to know if they are stateless or not.
Durable solutions are long-term solutions for refugees that allow them to rebuild their lives. There are 3 types of durable solution: voluntary repatriation to the country of origin when it is safe for the person to do so, local integration in the host country, or resettlement to another country which has agreed to allow the refugee to build a new life there.
Also, for the prevention of statelessness among refugee children, we have to know which refugee parents are those who don't have a nationality, because in that case, different prevention mechanism will have to apply, as in the case of those who have at least a formal nationality. But also those migrants who are not refugees, it's indispensable to know for authorities in host countries who are stateless or who are not. In case of refugees and asylum seekers, it can be truly difficult for states to carry out a formal statelessness determination procedure.
A statelessness determination procedure is a mechanism through which a state identifies stateless people in their territory so that they can enjoy basic human rights.
First of all, because normally a key element of this process is contacting with the state authorities of the country of origin, where the person used to live, where his or her family lives. This, in case of refugees, is prohibited because it would put these asylum seekers or refugees at serious risk of persecution. So states should actually use other methods, using country information, documentary evidence, and we should never forget that statelessness should always be established to a reasonable degree. Also, states should carry out this task because once the armed conflict ends, they may revoke refugee protection. There is the famous cessation clause in the Geneva Convention on Refugees as well.
Cessation of refugee status under the 1951 Refugee Convention means that due to a change of circumstances in their home country, a refugee no longer requires international protection.
But those who are stateless may still benefit from a continued protection regime because their statelessness will not disappear just because of the end of an armed conflict.
What impact can statelessness have on refugees?
I cannot tell you what is it to be a refugee, because that is something that only refugees themselves can really express. But refugees face innumerable categories of needs. They have been uprooted from their country, they have been uprooted from their home, expelled, persecuted, they have to cross a border, they are in a completely new environment, they don't have assets, they cannot obtain livelihoods, very often their documents about their identity are lost, or they never had them in the first place. They are in an extremely vulnerable situation. Very soon was that again refugees will face many different types of legal problems And in order to address those consistently, we needed to focus. So a very important element of what we do is to focus on very specific themes. One of them is housing, land and property. And the second most important one is issues related to legal identity, which includes civil documentation, access to birth certificates, etc., etc. It was, as many or most of the things that we do, it was brought up by some of our colleagues in the field that identified this as being being already a priority, but somehow gaining visibility within their country programs where they were working, and asking us to explicitly take into our program policies the need to address the plight of statelessness persons as well. And naturally, that falls within our legal identity work, because we know that access to nationality is often very dependent on the possibilities of accessing civil registration and so on, and obtaining documents on civil status. Not only, but these are very important. So it was a natural match that we had to embrace this, but it was also very much indicated by our colleagues in the field that we could not go on ignoring this.
What citizenship problems can refugees face?
People, when they move, are put into situations of terrible uncertainty. And I think the problem is that you have a lot of people who've left their country for one reason or another. And then after a certain number of years, there's discussion, maybe there's a peace agreement signed in their home country, or maybe there isn't. But you have these many, many refugees who are in a protracted situations of displacement, and their allegiance and their rootedness to the country from which they fled decreases often over time. That's not always the case. Many people are desperate to go back to what they see as their homeland, but for many people that's not going to be a possibility, either in the short term or in the long term. And so there are a lot of populations of people who've been displaced, whose citizenship, if you like, becomes increasingly unclear over time. And then of course you've got their children who are born in exile, who are then in an even less clear situation often, and even where there might be laws that determine their access to the citizenship of their parents, they might not want to take that up, or there may be other reasons why that becomes very difficult.
From their perspective, again, it's difficult to put oneself in their shoes and ask from their perspective, but we humanitarian workers and lawyers know that having the right to nationality is very important. Once that you lose that right, that you lose your nationality and you cannot enjoy it, then your vulnerabilities are going to be much more accentuated. You are going to face yet additional problems, not only those associated to being displaced, but also those being associated to being stateless displaced. And for us to try to prevent that further harm that is happening to this population is very important.
Protecting children's right to nationality. Why is birth registration so important?
Well, birth registration, it's essentially the first recording by the state of a child's existence. It's when the civil registry records the name of a child, usually, and his or her parents' names and where they were born. And it's the first form of recognition by the state that this person exists. And that's part of why it's so important for UNICEF, because it's a fundamental right of every individual to be recognized by the state. But it's also important for us because having that identity is the key to unlocking so many of the other rights that the Convention on the Rights of the Child guarantees for children.
The Convention on the Rights of the Child is the most widely ratified human rights instrument in the world. Under Article 7, every child has the right to be registered immediately after birth and has the right to acquire a nationality.
Birth registration generally records one or both, actually it records both of the two main ways by which people establish their nationality. If a country operates nationality law that is based on jus soli, Well, the birth registration and the birth certificate will say this individual was born in this place on this date, and so they're able to demonstrate this. But because it has the names of your parents and it shows where you're coming from familiar-wise, you also have the proof to be able to demonstrate if nationality is derived from jus sanguinis. And so you're always going to find one of the essential means of proving nationality is contained in the birth registration record, and so that's why it's absolutely vital.
The two main ways in which a child acquires nationality at birth are jus soli and jus sanguinis. Under the jus soli principle, a child acquires nationality by birth in a country. According to jus sanguinis, a child acquires nationality by descent from a parent who is a national.
The registration itself doesn't automatically accord nationality, it simply registers the birth, where and to whom. But that information is what tends to be essential to being accorded nationality. In some places, there are very practical barriers. Birth registration should always be performed and recorded by the Civil Registration Authority, which is the official government body that has that responsibility. And they don't always have offices in multiple locations throughout a country, and so it might be necessary for a family to travel quite a distance to be able to register their birth, and that means taking time away from work. It perhaps means having to find money to stay overnight in a city far from home. In other cases, there's an actual fee attached to the registration itself, and so all of these things, if a family doesn't have much money, they can disincentivize the act of registration. In other cases, people are afraid, for example, if they are an undocumented migrant family, they might have concern that this is going to bring me into contact with the government, and if I register my child, then somebody will turn up in a week and start making inquiries about migration status. And in other cases, people just don't know that it's important to have their child registered. There's maybe not much awareness in their community. They themselves were not perhaps registered as a child, and so they don't realise the possibility of the challenges their child could face further down the line if they don't get them registered.
What can be done to address barriers to birth registration, especially in the context of displacement?
That's often required in many countries to be able to register a child is that the parents themselves have to show their birth registration documentation. They might have to show their marriage certificate. They might have to show any other number of documents, and obviously communities and people that have been displaced, and particularly in times of conflict, they don't necessarily carry those documents. It's not the first thing you think to carry with you when you're leaving home. Also, there can simply be a reluctance when people have crossed borders by civil registration officials and others to register people who they perceive as being foreigners. They might confuse registration with automatically giving nationality, or they might simply not know that they have the possibility or the right to be able to register a family. I think the first one is that, and as a lawyer I probably shouldn't be saying this, but for every set of rules that are established, one can always create exceptions. Those exceptions have to take into account the fact that it's so important for a child to be registered, and that it's his or her right to be registered, and that the civil registry and the system of registration should be accommodating itself to the children that are presenting themselves to be registered, rather than insisting on adherence to one set of rules which may apply to one group in the population and simply not be possible for the others. And so in this kind of situation, for example, the rules can be relaxed a little in a specific set of procedures which require less documentation and can accept witness testimony regarding the place of birth. Those can be implemented. You can also have midwives who are trained to assist mothers through the process, because these are the people who are going to be coming into contact with a pregnant woman, and they can tell her even before she's having the child When he or she is born, you get them registered, they can tell them how to do that. And if necessary, you can try and carve time in the schedule of the midwives to be able to accompany the mother through that process. Or also there are lots of local NGOs that are willing, if you make the connection when a newborn has arrived in the family, they can follow up and walk the parents through the process. So those are a couple of very practical things that can be done.
As you've heard from these experts, not all refugees are stateless, and not all stateless persons are refugees. However, at least 1.5 million refugees around the world are also stateless today, and many more refugees may be at risk of statelessness. This is why it's really important for people who are working in the area of refugee protection to understand the way in which statelessness may interact with their work. Statelessness can be a root cause of forced displacement. It can also be a consequence of forced displacement if measures are not taken to address it. Stateless refugees can also be more vulnerable because they lack a nationality while in displacement. In the second part of this training video, you'll hear more about the ways in which statelessness affect refugees specifically in the Syria context. Thanks for listening.